Good afternoon, everybody, and welcome. My name's Matthew Harding, and I'm the chair of the Board of Directors of the Charity Law Association of Australia and New Zealand. And it's a real pleasure to welcome you all to this webinar, where a distinguished panel is going to lead a discussion about an issue of great interest and importance to the charity sector in Australia today. Let me start by acknowledging that I am situated on the traditional lands of the Wurundjeri people of the Kulin Nations and pay my respects to their elders past, present and emerging. I'd invite you to pay respects to traditional owners wherever you are in Australia or elsewhere. And I welcome any Aboriginal or Torres Strait Islander Australians who've joined us today. In a moment, I'll introduce our speakers and the order of proceedings. But again, welcome to all of you, including Led Hunter QC, who I understand is joining us from Canada. And I do hope it's not an ungodly hour there, but welcome, we're very glad to see you. The way we'll run this session is that each one of our speakers will make some comments in relation to the proposed regulatory reforms, and those comments will take each speaker between 7 and 10 minutes. After the speakers have concluded their comments, there will be time for questions and discussion. And I will welcome those questions either through the chat function of Zoom or using the little blue hand thing or signal that you can use to indicate that you're raising your hand. And hopefully we'll have 15 to 20 minutes for that at the end. Let me then introduce our speakers. We're going to hear first from Murray Baird, former Assistant Commissioner and General Counsel of the ACNC, and of course a leading practitioner now and for many years before he joined the Commission. Murray will then be followed by Dr. Murray Wesson of UWA, a leading public lawyer with an interest in this space. Following the second of the Murrays, we'll hear from Emeritus Professor Miles McGregor-Lowndes, well known to you all, of QUT. And finally, we're very privileged to be joined today by Reverend Tim Costello, who needs no introduction, one of the great leaders of the charity sector in this country. And Tim, we're very grateful that you've joined us today out of a very busy schedule. Let me just acknowledge that this is a very blokey lineup. That was not how we had originally intended the panel to be constituted. In fact, Sari Baird was going to chair the panel, and only a few hours ago we had to step out of that role because of work commitments. So apologies that this is not a panel that represents the commitment to gender diversity and inclusion that CLANZ strongly holds. But hopefully you can understand the reasons why. And that's not in any way to diminish the very significant contributions that each of these speakers promises to make. And so without further ado, I will hand over to Murray Baird and look forward to hearing what each of our panellists has to say.
Thank you, Matthew, and thank you to CLANZ for bringing us together for this consultation in a very brief consultation period. And I also echo the acknowledgement of the traditional custodians of the various lands on which we are meeting, and also send my greetings to Led Hunter in Canada. Thanks very much for the interest that people in Canada and New Zealand and other places are showing towards developments in our charity law and regulation. Compliance with the ACNC standards set out in the ACNC regulations is a condition of ongoing registration as a charity, and subsequently is a prerequisite for accessing certain Commonwealth tax concessions, including income tax exemption, and in some cases, deductible gift recipient endorsement. Currently, Governance Standard 3 provides that registered charities must not act in a way that may be dealt with as an indictable offence or by way of a civil penalty of 60 penalty units or more. And as the note to current Governance Standard 3 points out, Australian charities must comply with Australian laws. But a serious infringement of Australian laws may trigger the Commissioner's enforcement powers and lead to deregistration. Now, this isn't simply a provision that states the obvious. Charities must comply with the law. It creates a higher standard for charities not known to other entities in the community. We know the standard of proof for a criminal matter is proof beyond reasonable doubt after a hearing on the evidence. But the standard of proof for enforcement powers under the ACNC Act in this context is where the Commissioner reasonably believes that a charity has not complied with a governance standard, or it is more likely than not that the charity will not comply with such a standard. That is, a perception that a charity might do something in the future. And we know in our current media that there have been recent appeals to the rule of law, and they may well be relevant here. So what's the proposal? The essence of these proposals is that the trigger for enforcement action by the ACNC now extends to summary offences relating to property or the risk of harm to people. And I submit that it's hard to imagine any summary offence that doesn't relate in some way to property or a potential harm to persons. In general terms, summary offences are less serious offences that can be dealt with in the magistrates' court or local courts. So these provisions are not so much about a charity doing something illegal. That can be dealt with under the criminal law. It's about a likelihood that a charity might do something that could be dealt with as a summary offence. Not a likelihood that an offence may be committed, but that an act could be dealt with by summary procedures, presumably that there's enough to charge you with an offence. The next stage of the proposals is that they're not confined to a charity just doing things. They extend to a charity not taking reasonable steps to ensure its resources are not used for any actions that might be dealt with as summary offences. So use of funds and staff and directors and communications are all part of those resources that should not be used for prescribed conduct. The ACNC review report is referenced as something of a basis for these initiatives. The explanatory statement to the proposed amendments observes that the regulations implement the government's response to recommendation 20 of the Strengthening for Purpose Australian Charities and Not-for-Profits Commission Legislation Review 2018. And we'll go to the next slide if we may. Recommendation 20 states that test case funding should be made available to develop the law in matters of public interest. So in response to this recommendation, the government stated that it would explore legislative options to address uncertainty in the law. And I submit that it's a long bow to argue that the extension of the standard to summary offences is merely addressing uncertainty as an alternative means of rather than test case funding. But then why is this proposal here? It seems more likely, and we'll go to the next slide, it seems more likely that the catalyst is the frustration of some members of the government with activities of animal rights and environmental activists, whom it is alleged do economic harm in the Australian community and ought not be given tax preferments. I take that presumption from a reading of the proceedings of Senate Estimates Committee over recent years and the media release of the Assistant Minister for Finance, Charities and Electoral Matters that I've put on the screen. It is likely that these provisions will have a chilling effect on the activities of a range of charities beyond these particular governance targets. And there will be many charities, perhaps in the health area, the welfare area, and the religious area, who may be concerned that their use of resources or the actions of their staff or their directors could well put them in a jeopardy of losing their licence to be a charity and indeed their very existence if they rely on the tax preferment or that badge of charity to operate. So just some general observations. The movement in the wording from must not engage in conduct to must not do an act. The usual rule in legal drafting, different words, different meaning. It's possible to do an act. Could that be regarded as a single action? But whilst engage in conduct might denote a course of actions. It's difficult to see a real difference in the meaning, but the change does call for some sort of drafting explanation. Second point I'd make is to reiterate, no need for a conviction. The breach doesn't arise as a result of being charged with an offence or being convicted of an offence. It arises if the act could simply be dealt with as a summary offence. So what's an example? A responsible person attends a protest rally and it's alleged that the person trespassed on private land, perhaps unintentionally. There's no need to prove trespass, merely that the alleged offence could be dealt with as a summary offence, regardless of the proofs, regardless of the defences, including those constitutional defences such as referred to in Brown and Tasmania, the 2017 High Court case. Any form of civil disobedience in the course of pursuing a charitable purpose may now risk the existence of a charity. The scope of the responsibility, a charity must take reasonable steps to ensure its resources are not implied in a way that supports a prescribed action by another. For example, a volunteer director is deemed to be a resource of a charity when acting in that capacity. So any statement made by such a person that may be taken to support acts of another person that could be dealt with as a summary offence is caught. So a responsible person tweets, if this facility is going to be built in this location, I urge the community to fight against it. So in conclusion, these proposed amendments are not a proper response to strengthening for purpose. That report said that Governance Standard 3 indeed ought to be removed. The concern in the report was not about summary offences. It was about the line between advocacy and partisan political activity, which is, of course, a legitimate concern in charity law. The proposals put unreasonable and discriminatory burden on registered charities and a chilling effect on the actions of charities, staff, directors and their supporters in the course of their charitable purpose. And the proposals could lead to the removal of concessions and threaten the very existence of a charity as a result of potential summary offences. In closing, I think that governance standards should not be any instrument to limit any activities of charities that attract government disapproval. There are other methods of dealing with activities of charities which offend the law, and it's more appropriate that they be used. But thanks very much, Matthew.
Over to you, Murray Wesson.
Thank you, Matthew. I'd like to start from where I am in Western Australia by acknowledging the traditional custodians of the land, the Whadjuk Noongar people, and paying my respects to their elders past, present and emerging. Thank you for the invitation to participate in this panel. I should also say at the outset that my presentation is drawn from a submission that I'm working on with my colleague Ian Murray at UWA Law School. Ian is a charity lawyer. I'm not, I'm a public lawyer, so I'm a bit of an outsider. but I'm going to hopefully bring a public law perspective to bear on these proposals. And what I hope to do in my presentation is to discuss the regulations in light of the implied freedom of political communication. And what I'd like to suggest is that the proposed regulation, which Murray, I should say the first Murray, the other Murray, discussed in his presentation, which is the obligation that would be placed upon charities to take reasonable steps to ensure that their resources are not used to promote certain acts or missions, arguably breaches the implied freedom of political communication and is possibly therefore unconstitutional. Now, just by way of introduction, the Australian Constitution, as I'm sure many people here are already aware, does not contain an express right to free speech. Instead, it contains an implied freedom of political communication. And the implied freedom of political communication is enforced by way of a three-part test that's referred to as the Lange test. Now, the Lange test has become increasingly elaborate. I've kept my slides to a minimum, but I thought it would still be helpful to set out the steps of the Lange test for the purposes of my discussion. And what you should be able to see on the screen are the three key questions that are addressed in the Lange test in determining whether legislation breaches the implied freedom of political communication. Step 3 is divided into a further 3 steps nowadays, and I'll get to those later in my presentation. But I'll start with the first of those steps. And the first question that's addressed when the issue is whether a law breaches the implied freedom of political communication is whether the law effectively burdens freedom of communication about government or political matters, either in its terms, operation, or effect. And here there's very clear High Court authority that protests are an important means of political communication. The case of Brown in Tasmania has already been referred to. However, I should also say that it's also very well established in the High Court's case law that the implied freedom of political communication does not protect unlawful conduct. So where political communication in the form of a protest or otherwise breaches a law that itself is not constitutionally suspect or invalid, then that protest or communication is not protected by the implied freedom of political communication. And so for that reason, in my presentation, I will not be addressing the proposed regulation which says that an entity should not do an act that may be dealt with as a summary offence under Australian law. I acknowledge that there may be other legal concerns raised by that proposal, but I won't be focusing on that for the purposes of the implied freedom of political communication. Instead, I'll be focusing more on the proposal that an obligation should be placed upon charities to take reasonable steps to ensure that their resources are not used in certain unlawful ways. And as has already been noted, what this proposal brings to mind immediately is the idea of a chilling effect. Now, the chilling effect is a doctrine that one finds in US constitutional law. In essence, what it refers to is that persons might be deterred from engaging in protected forms of communication or speech, that is constitutionally protected forms of communication or speech, by laws that are not directly aimed at those activities. And one can see how this proposal might have application here for the reasons that Murray Bard has already alluded to. However, the status of the chilling effect is somewhat unclear in Australian constitutional law. That said, even though it hasn't clearly been adopted as a doctrine in Australian constitutional law, in Brown in Tasmania, a majority of the court certainly took an analogous approach. So there we found the joint judgment, that is Chief Justice Kiefel, Bell and Keane, as well as Justice Nettle in his separate judgment, referring to the practical effect of legislation in Tasmania that related to protests on forestry land. And the joint judgment, as well as the judgment of Justice Nettle, both emphasized that in its practical effect, the very vague and open-ended nature of the legislation, as well as the discretion that was concentrated in the hands of police officers monitoring protests, was likely to have a significant deterrent effect on protesters. And so, even though it's not clear if the chilling effect is part of implied freedom of political communication case law in the way that it is in the US, it's certainly the case that an analogous approach was, I think, taken by the majority in Brown in Tasmania. The risk that a charity faces if it breaches this proposed standard is that it may lose its registration and certain tax benefits. There is a question that Ian, my colleague, has put to me about whether that is a burden on the implied freedom, that risk of a loss of tax concession. And the court in its case law has been very clear that even a minimal or a little burden on the implied freedom is sufficient to engage the Longy test. As well as that, there is Canadian case law, and that's the case of Canada Without Poverty and Attorney General of Canada, which under the Canadian Charter recognized that a loss of tax concession would amount to a burden on freedom of expression under the Canadian Charter. So I'm confident that the first question here is engaged. That is, there is a burden on the implied freedom. The next question we then proceed to is question 2, whether the purpose of the law is legitimate. And here, as Murray Bard suggested in his presentation, there is a certain ambiguity about what the purpose of these regulations are, or proposed regulations. But then if we look at the exposure draft explanatory statement, it states there very clearly that the ostensible purpose is to address uncertainty about when engaging in or promoting certain kinds of unlawful activity may affect an entity's entitlement to registration under the Act. I think that is a legitimate purpose. It's one that's compatible with the constitutionally prescribed system of representative and responsive government. Then it then takes us to question 3, which is whether the law itself or the proposed regulation is reasonably appropriate and adapted. I think that takes us to the next slide, where, as you can see, the Longy test has become increasingly complex, and the High Court has imported a notion of structured proportionality, which is used in rights adjudication in many jurisdictions around the world, into its implied freedom of political communication case law. Now, noting that I don't have a great deal of time to run through this test, I just wanted to point out how I think it is strongly arguable that the proposed regulation imposing an obligation on charities to take reasonable steps fails at each of these stages of the structured proportionality test. So the first question is one of suitability. Does the proposed regulation have a rational connection to the purpose of the provision? And here, just a reminder that the purpose of the provision is to promote certainty, but given the very open-ended nature of the proposed regulation, given the extensive discretion that would concentrate on the hands of the ACNC Commissioner, I think even though this standard is a deferent one, it is not a particularly searching standard, it is arguable that this proposal would not in fact promote greater certainty and therefore fails even at the suitability stage. The next question is necessity. And here what the court will consider is whether there's an obvious and compelling, reasonably practicable means of achieving the same purpose that has a less restrictive effect on the freedom. And in essence, what this asks the court to do is to consider whether the legitimate purpose, here promoting certainty in the governance standards that apply to charities, can be pursued in a way that is less burdensome on the implied freedom, but also reasonably practicable. Now, it should be noted here that the alternative measure does not need to be equally effective. It simply needs to be reasonably practicable. And here, one could point to the possibility of simply a prohibition upon charities acting in unlawful ways, rather than this additional requirement of reasonable steps being taken. Finally, and I'm aware that I'm coming to the end of my time, so I'll just try to wrap up. Is the regulation adequate in its balance? This is a balancing exercise. The court will approach it cautiously, given that there's a degree of value judgment involved. But here too, I'd submit that if the practical effect of the proposed regulation, that is the requirement to take reasonable steps, is to act as a deterrent to protests at a cost to the implied freedom of political communication through a doctrine analogous to the chilling effect, and the benefit is actually to promote greater uncertainty in the governance standards that apply to charities, which is the ostensible purpose of the proposed regulation, I think too that the law is at least suspect also at the balancing stage. So I think I'll just I realize this is a complex area of case law that I've run through fairly quickly, but I'm at the end of my allocated time, so I think I'll wrap up at this point.
Thanks so much, Murray. Miles, I'll get your slides on the go, and feel free to start when you like.
Thank you very much, Matthew. I'd like to acknowledge the traditional owners of the land on which I'm zooming today, the Agra people. Let me say that at the heart of this is discretion. The proposed regulation is a significant width of discretion afforded to the Commissioner. The courts since 1598 have pushed back on such wide discretions by commissioners. In 1598, Lord Cook in Rook's case said of the wide discretions given to no less than the commissioners of the London sewers, he said, notwithstanding the words of the commission gives authority to the commissioners to do according to their discretion, yet their proceedings ought to be limited and bound with the rule of reason and law. For discretion is a science or understanding to discern between falsity and truth, between right and wrong, between shadows and substance, between equity and colourable glosses and pretences. In my view, such discretion should be the subject of fulsome judicial review if they have to be granted. Thank you, Matthew, for the slide. I point out that the Senate Standing Committee for the Scrutiny of Bills, when looking at the ACNC bill, said that the Commissioner's discretionary powers were not clear, and whether there was a de novo review appeared to be missing. This was confirmed in the Warburg Foundation case decision, the only reported case decision to date, and further in the ACNC review documents at page 37, they suggested that a de novo review of the Commissioner's decisions be available to aggrieved parties. On further digging down into the Senate Scrutiny of Bills Committee report, they identified not only the de novo review provision was a departure from the standard model of merits review applicable to the ACNC Act, but they also pointed out that Section 27 of the AAT Act allows applications to be brought for review by or on behalf of any person or persons whose interests are affected by the decision is excluded in the ACNC legislation. And I just think, wouldn't that be interesting, particularly if we get a marketplace of donors, if donors were so empowered. But I leave that. Matthew, if we can go to the next slide. I just want to draw a couple of things about the regulatory impact statement and the explanatory memorandum. Firstly, the EM doesn't have its statement of compatibility with human rights yet, and I think that will be an extremely interesting piece of work. The Delegated Legislation Standing Committee will be concerned on those 3 points if they find that it makes rights, liberties and obligations dependent or insufficiently on administrative powers. It trespasses unduly on personal rights and liberty. It unduly excludes, limits or fails to provide independent review of decisions affecting rights, liberty, obligations or interests. And I'm particularly concerned with that third one because I think it does without a de novo review of Commissioners' decisions. Going back to the regulatory impact statement, we haven't, this doesn't appear to have been made public yet, but should have accompanied the procedures to Cabinet and the like, and hopefully it will be made public. This should give us an idea of what the drafters thought of the regulatory costs that non-profits will have to face because of this regulation. And I know that there's a fair bit of discussion and talk that these could be significant, and I think they could be for some organisations. And more importantly, the alternative measures that were considered to suppress the mischief here. What alternative measures? And I just throw out one thought here. Section 45.10.4 of the ACNC Act allows the Commissioner to endorse standards for various types of entities. And so, you know, an example of that is the ACFID Code of Conduct. would it not be possible, not beyond the wit and wisdom of Australian non-profits, for those who engage in public protesting to come with a code of how you safely and appropriately conduct public protest and have this endorsed by the Commissioner? So there are various ways of skinning the cat, and this is a cooperative way, and I think would be more long-lasting and more beneficial, and create less litigation cost and associated problems, and a chill. But perhaps it's not. Perhaps a chill is what is wanted here. But you know, a code of conduct drafted up by the sector and the ACNC may well be quite an interesting proposition. Next slide, Matthew. I just want to draw your attention to Canada, and thanks for coming on, Laird, but political activity hunts have gone on by the CRA, where they got 13.4 million Canadian to do political audits, and they were going to look, they did 54 charities in the end of it. It was a long and drawn out process. My point here is that very few of them were knocked off the register for political activities or purposes. We don't know exactly the number, but it was very low, between one and five. Most of them were knocked off because when the auditors went in, they found other things wrong with the charity, other indiscretions, such as not keeping appropriate books and records, minutes and the like. And so there are lots of compliance agreements and education letters. So the chill was achieved in a different way. If the next slide, Matthew, I call this Al Capone regulation. You might remember that Al Capone wasn't sent to jail for his nefarious activities, but the Attorney General took him to court for not filing his tax returns on time, and he received 11 years in federal prison and a whole lot of fines. So getting somebody under an easier cop is, I think, what's happening in some systems here of non-profits who've been struck off, who've shown me ACNC reasons for doing so. And let me just give you two Al Capone strategies that the ACNC may well employ once an audit has been triggered or an investigation has been triggered. That's breach of governance standard 5, a failure of responsible persons to perform the care and diligence required in organising public protests. And from the material I've seen that's generated from the ACNC, they're asking for all sorts of things of public protest charities, written records of their pre-event briefings, training workshops, risk assessments of the location, volunteers with first aid knowledge being present, group leaders and provost marshals, permits, notification of the police and road authorities, local councils, legal observers, and debriefing, and that's all got to be documented. That training was done on some Facebook page, which has now been taken down, is of little benefit. And then it's followed up by section 55.5, our books and records section, which says that, you know, if they haven't kept written records that correctly record its operations, and all of these various permits and legal briefings and having volunteers with first aid, then you can be dealt with under the discretion. So most small charities, this is a significant ask. And where's the proportionality? So it becomes a tussle between what's proportionate that they should attend to, which is in the Commissioner's range of considerations, but what is for the protection of the public when you're engaging in quotation marks, sort of dangerous public protests. Next slide. Yeah, I just want to draw your attention, you may have overlooked, I certainly did, this section in the ACNC Act with respect to political advocacy, and it deals with the regulations. It was a late amendment to the Act proposed by the Greens, and the revised explanatory memorandum makes interesting reading, although it does say that such a section doesn't countenance illegal activities. The other thing to know in the Act about the governance standards is that the regulation or the instrument won't come into effect on the day after registration of them. It is delayed until those other things happen. Next slide, Matthew. And to cap it all off, the Act also lays down some rules about consultation. So the Act clearly says that the Commissioner must conduct appropriate consultation, and it actually lists the bodies there. So even if this does get through and into Parliament, the Commissioner will have to undertake a whole series of consultations as outlined there. So, in closing, I say I think this has got a long way to go. Including, I would be very surprised if the Senate Scrutiny of Regulation and Bills Committee didn't give it a very thorough going over, particularly about the width of the discretion, which is already noted previously in the Act, and de novo review. Thank you, Matthew.
Thanks very much, Miles. Tim, over to you now.
So I also acknowledge the traditional owners of the land I'm on, the Bunurong and the Kulin Nation. And I just want to endorse the extremely contentful presentations that you've had, and say that I am speaking wearing the hat of co-chair of the Charities Crisis Cabinet and chair of the Australian Communities sector. So those charity hats, to say that this already is having a very chilling effect on a whole lot of our members and causing great angst. As I was listening to Miles, I was in a little bit of a conflict of interest. I don't want the Al Capone strategy applied to charities in Australia. I'm totally with you. But I say with some schadenfreude, I sort of hope it gets applied to Donald Trump. If they couldn't get him on insurrection of the Capitol, they might on tax. So that leaves me in a very inconsistent place. However, Miles, I totally agree that when it comes to charities, the Al Capone strategy of unearthing stuff is having a chilling effect. I might just say that in the sector, our approach will end up being pragmatic by trying to water this down. But in terms of our principles, we are feeling put upon, that this is overreach, that this is applying a wide discretion in the Commissioner without appeal to charities. That isn't applied to political parties or to the corporate sector. And we're wondering why this overreach and targeting of charities is going on. And in principle, I think I speak for most saying we would want to see this not proceed. Some of you will remember that in May 2016, Scott Morrison aired allegations that Save the Children were coaching self-harm for asylum seekers. And later he refused to apologise when it was shown that wasn't the case. He said nothing wrong with just airing allegations, and that's what he did. He's got nothing to apologise for. But I wonder if this went through and a Prime Minister again made a charge that really did damage the reputation of Save the Children, what the Commissioner, with very wide discretion and no real rights of appeal, would do in that Save the Children situation. The Attorney General, Christian Porter, who's been very concerned about reputation, this is pre the current events, he, in an address to the National Press Club in 2019, described the rights of an individual to protect their reputation as the foundational goal of any liberal democracy. It's as important as detecting and deterring corruption. And he went on to say that he saw reputational risks in places where others haven't. In 2019, he launched a crackdown on, of all things, an animal rights website, because he believed that website, by revealing the location of abattoirs, exposed farmers to smears. Their reputation was somehow at risk by publishing the location of abattoirs, which are pretty freely available anyway. When we think of the political sphere, you know, most of us who have been consumed by the terrible events of the last 2 weeks wonder, well, if political parties can't, it seems, protect their own employees from harassment and even sexual assault, does anyone actually say there should be somebody that has the discretion, a wide discretion, to deregister those political parties? And yet we feel, of course, that won't happen there, but it's happening to us. We feel that with corporations. Rio Tinto can blow up 40,000-year-old rock paintings in Juukan Gorge. And yes, there's some fines and some changing of the board, but no one says Rio Tinto should be investigated and deregistered. I've had 25 years of advocacy work, first with the Interchurch Gambling Task Force, now the Gambling Alliance, saying Crown Casino is laundering money. It's enabling organised crime. At times, Crown has been fined for putting picks in poker machines and keeping them running all the time, but slap on the wrists. The Interchurch Gambling Task Force and I were sued by the regulator when I called them weak back in 1998, sued for defamation, a charitable body, and I sued. But I simply make the point now that we've had findings that Crown were in league with criminal junkets and triads and enabling crime through their money laundering. Yes, there's an inquiry into their fitness and proper purpose, but Crown will no doubt reform its board. James Packer will sell down his 37%. Crown will go on. No one is saying it should have been deregistered. So I just point these things out to say that there is this profound sense in our sector, not only of the chilling effect and the regulatory cost, but of profound double standards, not a level playing field, a level playing field that seems to apply to political parties or to the corporate sector. And that is already causing distress within our sector. So they're just some comments. I'll throw back to you, Matthew.
Thank you very much, Tim, and all the panelists for those comments. There's quite a lot of food for thought in all of that. And so I'll be very happy now to field or to take any questions or comments for the panel. Either you can just type them into the chat function, or you can raise your hand in one way or another. And I'll take them that way as well. So I might start this process of getting the discussion going. And it's a question that perhaps Murray Wesson might be best placed to answer, but it also relates to what Tim has just said. There is a sense in which measures like this single out the charity sector for treatment that we don't necessarily see being meted out to other sectors. And I suppose one view of that would be that government perceives that political activism and agitation in the charity sector is especially threatening or especially something to be watched and controlled. But in that is a question that I think goes to this constitutional question that you were talking about. The charity sector seems to be a place where people can be especially effective in having their political voices heard. And I'm thinking now about the reasoning in the AidWatch case, where the High Court of Australia, appealing to the implied freedom of political communication, reasons to the effect that, well, charity advocacy is something of public benefit. It's making a contribution to our system of representative and responsible government that's distinctive and important. And I wonder, is that a factor that you think would be taken into account if the constitutional questions that you were talking about earlier ever got tested in relation to these regulations? I'd be interested in hearing.
Yeah, thanks, Matthew. I think that's a really good question. And I do think those considerations would be relevant. The reason I think that is that in Brown and Tasmania, where the legislation targeted environmental protests on forestry land, the High Court acknowledged that there was a history of environmental protests in Tasmania, and that history was relevant to considering the impact of the legislation. And so that was taken into account. And I can contrast that with a subsequent implied freedom case, which was Clubb and Edwards, Preston and Avery. That was a case about restriction zones around abortion clinics, and there's a prohibition on protests within those zones. And the court there said that there was no analogous history of protests around abortion clinics that needed to be taken into account. So I think the fact that in Brown, the High Court there acknowledged that this history of environmental protests in Tasmania is an indication that, as you say, the value of protests in the charitable sector is something that would be considered when assessing the burden on the freedom. So that first step, where the court were to, if this became a constitutional issue, where the court considers the nature and extent of the burden on the implied freedom of political communication, the fact of a significant chilling effect on a sector where protests have historically been an important contribution to Australian democracy, would certainly be something that would be taken into account, I think.
Yeah, thank you for that. While we're with you, there's a question in the chat from Bridget Cowling. Hi, Bridget. Talking about, well, the question is, do we have a good argument about lacking a constitutional head of power for, I suppose, the legislation giving Commissioner these powers? The taxation power, has limitations here.
Sure.
Do you have thoughts on that?
I'm not sure I do, actually. It's not something I've turned my mind to, but I will. So I'm reluctant to give an answer without having thought it through.
In the chat, Ian Murray offers some thoughts. He says, good question, although the tax power is typically interpreted quite broadly. It, for example, supports the superannuation guarantee charge, which is expressly designed not to raise tax. But of course, that there are different views expressed on that point, as you would know, and so it's an interesting question.
There's also the corporation's power for charities that are incorporated. So.
Jennifer Petruni writes, hi Jennifer, the charity sector has and will speak against this sort of legislative overreach via the mandated consultation, but she writes, our concerns seem to fall on 10 ears. What is the best strategy to have our concerns heard and acted upon? Would any of our panellists like to address that question?
Certainly there has been a call for submissions, and although some peak bodies will be making submissions, I think it would be appropriate for individual charities to make submissions that point out what the effect will be on their particular charity. Perhaps it may be that for you there will be an administrative burden, but whatever that concern is, even a short submission, it doesn't have to be in a particular form. Just go to the Treasury website, find the link, and that will have a guide to how to put in the submission. I note Erica's comment that be careful that you don't, in fact, breach the requirement of the regulations by entering the political arena. Stick to the issue, don't go partisan.
Yeah, can I just add to that, Matthew? I think Jennifer's question is a really good one. One of the things we've really lacked as a sector is breakthrough ability to explain to politicians our size and our reach and our contribution to GMP, and that 8% of the Australian workforce are employed actually in the sector. And when we were first left out of the JobKeeper package, and I talked to the Treasurer, Josh Frydenberg, he was absolutely amazed, stunned, when I told him the employment size and the GDP size of this sector, and he'd never heard of that. We are now finally getting some breakthrough on fundraising rules. We've had a campaign to fix those with state ministers to reduce the red tape, only because they are starting to understand the economic grunt in the sector. It's not simply a matter of a few voluntary people who are bleeding hearts. So I think communicating it is communicating our scope and contribution as a sector is part of the strategy here.
Thank you, Tim. Now, Erica Myers-Davis has raised a question about whether CLANZ itself will be making a submission, and my understanding, well, my sense of that is that members of the CLANZ board are very active in that process, but CLANZ itself has not at this point made a decision to put something in. That's something I can raise with the board again in the coming day or two. Sue Barker writes, hello Sue, Sue's from New Zealand. She writes, the argument I often hear raised is that charities receive tax privileges and therefore their advocacy work should be subject to government control. Sue says, personally, I do not agree with that argument, but I'd be interested in the panelists' thoughts about how best to counter it. Would anyone like to respond to that?
Well, non-profits aren't the only people who get tax privileges, and when you look at the list of the size of tax benefits, for-profits have well and truly got their snouts in the trough with all sorts of tax expenditures, but we never hear any rhetoric about their depreciation or their diesel fuel rebates or any other number of fiscal concessions being taken away if they blow up sacred lands. So I think you've got to get it in proportion. The other thing that I really rail against is nearly everybody in Treasury talks about generous tax concessions. Well, they want to have a look around the world. Australia doesn't necessarily compare well with some other places and their tax exemptions and concessions. For example, donation deductibility for all charities, not just a privileged few.
Thank you, Miles. Any other panelists like to address that question? Just on that last point, Miles, I was struck when I was in Singapore last year to learn that the deduction, at least in the case of certain charities in Singapore, is 250%. A very clear signal that the state there is sending to donors to give to favoured causes.
And just talk to anybody in North America when you say putting some money in the offering plate at church is not tax deductible, and they go, how do your churches exist? But anyway, there are some significant differences between the generous nature of their tax concessions compared with ours.
I have a question or comment here from Rosemary Langford that one or more of you might like to respond to. She writes, potentially this could deter people from volunteering to be on the board of charities, given that the duty of care can be triggered by causing or allowing an entity to breach the law. Justice Falk in the Kids Company case warned against such deterrence in a different context, but nonetheless the warning was given. Any reflections on that, this disincentive that this might give to people who would otherwise be serving charities in governance roles?
I think it's true to say that the greater the burden that you place on charities generally for compliance, the greater the burden you place on volunteers who serve on boards and who have to deal with these matters. And so you do discourage participation. And the intention of the Act, the objects of the Act, were in fact to encourage and really nurture the charity sector and not place an unreasonable burden. So every time an additional condition is given, it makes it more difficult to get the volunteer sector working.
Any comments on that from the other panelists? All good?
Well,
sorry, Miles, you go ahead.
I just say any of the large church welfare, community service operators, or any large denominations. I mean, there must be offences committed on a daily basis when you have thousands upon thousands of staff under your control, and workplace health and safety provisions with strict liability and vicarious liability. It is extraordinarily onerous, and you can do your best as a trustee or board member to put in policy plans and processes. But you know, these things are going to happen, particularly at the lower end of the offences spectrum. So I think it's going to be an issue for large and for small organisations.
Yes, it sort of takes me back to first year jurisprudence and the classes on the rule of law, and you know, Lon Fuller's famous description of the rule of law, and how one of its requirements is that, you know, you don't have rule of law where it's actually not possible to comply with legal requirements and directives because they ask more than is, you know, feasibly possible on the part of people. It's a pretty fundamental point that you raise, Miles. But before we finish, I might just ask if any of the panelists would like to end by making one further observation.
Just to answer a question, in my view, although this may be aimed at political protests, it includes any offences committed with property of persons, and so NDIS, NDIA, aged care facilities, schools, churches, youth groups, homeless centres, everybody who has the ability to commit one of those offences in a charity is lined up. It is extraordinarily wide, in my view, and so requires either confinement or at the very least de novo review of any exercise of the discretion.
I note Adam's point that what are the reasonable steps that an organisation could take? Whatever they may be, I suspect they will involve a dedication of a great deal of resource towards compliance questions rather than mission. And in my view, that is a waste of resources to try to cover off every possible summary offence that might occur rather than getting on with the job, and realise that sometimes you may offend and there will be a consequence for that, but it ought not be a consequence if you simply might offend.
Tim or Murray, did you have any last words you wanted to offer?
No, I think I've covered the issues that I wanted to discuss, so thank you. Thank you to the other panelists and for the questions too.
You know, I don't have anything else to add, thanks.
Well, can I just once again thank all four of you. We clearly didn't have enough time to do justice to what is a very important and concerning topic. And so let's hope that these conversations can continue and that people will make their contributions as the consultation process draws to its end. So once again, thank you to the panelists. Thank you to everyone who's come along. And for those who are interested in the chat, we'll make sure that that's available to interested people. Okay, so thanks again, and all the best to you.